Hello and welcome to Working Wise, a podcast created and produced by K&L Gates. Each episode is designed to provide labor and employment updates and compliance tips to lawyers and HR professionals. We hope you enjoy this podcast.
Welcome to K&L Gates Working Wise podcast series. My name is Leann Walsh and I'm a senior associate in the Raleigh office of the firm's Labor, Employment, and Workplace Safety Practice area. In this podcast episode, we're going to discuss several opinion letters issued by the Department of Labor's, the DOL for short, Wage and Hour Division on the Family and Medical Leave Act.
My name is Melanie Stratton Lopez, and I'm an associate in the Raleigh office who's also in the Labor, Employment, and Workplace Safety Practice area.
And my name is Avery Miller, also an associate in the Raleigh office in the same practice area.
Our practice includes helping clients across a variety of industries stay up to date and compliant with different labor and employment regulations, including state wage and hour regulations, the Fair Labor Standards Act, and the Family and Medical Leave Act, the FMLA for short. Interpreting and applying these regulations can be tricky for employers, even when their written policies are legally compliant. From time to time, the Wage and Hour Division of the DOL responds to fact-specific questions with official written explanations and interpretations to help provide the public with a clear understanding of what legal compliance in practice looks like. These letters of interpretation also provide insight into the DOL's enforcement positions.
That's right. It can be helpful to follow the DOL's thought process in applying the regulations to a real set of facts, which can, in turn, lead to better compliance for our own clients' policies and practices. These letters, while not the law, are more like official guidance.
Today, we are going to cover 3 opinion letters issued by the DOL in 2019 on the topic of the FMLA. We're going to talk about the letters one by one, and while the facts of each letter are different, there's a common theme between them regarding how to properly administer an FMLA leave policy. Before we dive into the details of the letter, Leann, do you want to provide a quick overview of the FMLA?
Sure. The FMLA entitles eligible employees to take 12 weeks of unpaid job-protected leave per year for specified family and medical reasons, or up to 26 weeks for certain military qualifying leave. Usually the employee needs time off of work because he or she is sick, the employee or the spouse is pregnant, or he or she needs to care for a family member with a serious health condition. When one of those situations arises, the employee communicates the need for time off to his or her employer and the circumstances around the need for the absence. Once the leave request is made, the employer has 5 days to investigate the situation and determine whether the leave is being taken for a reason that qualifies for FMLA protection. If the answer is yes, the employer officially designates the leave as covered. The law provides protections for the employee during that time. For example, the employer must maintain the employee's health benefits and allow the employee to return to his or her position, or an equivalent one, at the end of the leave period. This is just the legal minimum, of course. Employers are allowed to have more generous leave policies.
Okay, great. I think that brings us to the topic of the first letter. Melanie, do you want to cover that one?
Yes. So this letter, published in March of 2019, asks whether an employer may delay designating paid leave as FMLA leave or permit employees to expand their FMLA leave beyond the 12-week entitlement, meaning delay the designation that triggers the 12-week timer to give more leave. In the fact scenario in the letter, the employer had a policy of voluntarily allowing employees to use paid sick leave or other kinds of leave they had entered through employment before designating the leave as FMLA leave. In other words, the employer wanted to delay designating FMLA leave for an employee until the employee exhausted or used other types of leave, essentially delaying when the FMLA starting clock began. For example, let's say an employee had saved up 1 week of paid time off. If he notifies his employer that he's taking leave and it's for a reason covered by FMLA, he might want to use his PTO first, so that 1 week would pass before the official designation begins, the clock on FMLA leave. That would basically give him 13 weeks of protected leave, which is not permitted under the FMLA. This letter confirms, however, that this practice is not permitted. Employers cannot delay the designation to give more than 12 weeks of leave. There is a case cited in the letter, Strickland v. Water Works and Sewer Board of the City of Birmingham, which states, Congress intended that the FMLA provide employees with a minimum entitlement of 12 weeks of leave while protecting employers against employees tacking their FMLA entitlement onto any paid leave benefit offered by the employer. Instead, the employer may require the employee to use accrued paid time off that can run concurrently with FMLA leave. So if an employee had banked 2 weeks of paid vacation and the employer can make the employee use those 2 weeks at the start of the FMLA leave period, they run simultaneously. I wanted to also point out that there is a footnote in the letter addressing a Ninth Circuit decision, Escriba v. Foster Poultry Farms Incorporated. in which a court decided that an employee could elect to use paid time off or non-FMLA leave time for an FMLA qualifying event in order to save all 12 weeks of FMLA leave in case it was needed in the future. This letter makes it clear that the DOL disagrees with that court opinion. Under the DOL's interpretation, the 12 weeks must begin to run any time a qualifying leave reason occurs.
And Leann, that sort of ties into another one of the letters, doesn't it?
Yes, it does. This letter, the most recent of the 3 in 2019, was published in September. This employer, a local government agency, has employees who are subject to a collective bargaining agreement, a CBA for short. A CBA is a legal contract between an employer and a union representing the employees that governs the wages, hours, and other conditions of employment. In this case, the CBA provided that the employees must delay taking unpaid leave, including FMLA leave, until the accrued paid leave given by the CBA is used up. The letter goes on to say that after the DOL's letter was published in March, Melanie, that's the one you just talked about, the employer changed its policy to require paid leave to begin and run concurrently with FMLA leave when the employer becomes aware the leave is covered. This employee wanted to know whether that is necessary when the CBA provides a greater benefit to employees and that they would want to postpone. This employee was especially concerned about the paid leave because their CBA had policies on seniority. In the workplace, seniority can mean better job security, promotion eligibility, or other privileges. So under the CBA, seniority continues to accrue when paid accrued time is used. The letter essentially states that benefits, other than group health benefits, are according to the employer's policy. That said, the employer cannot discriminate against employees who take FMLA leave, and the employer cannot reduce or deny benefits given under the FMLA. The letter concludes that the employer's policy, which now requires them to use paid time concurrently with FMLA leave, is correct, not only because of the March letter, but because it allows seniority to continue to accrue for the time that the employee is substituting for unpaid FMLA leave. For example, let's say the employee has 2 weeks of paid leave by the CBA, and that the CBA states that seniority will only accrue during the paid leave, not unpaid. When the employee's leave that qualifies as FMLA protected begins, those 2 weeks of accrued paid time off begin to run at the same time. During those 2 paid weeks, the employee's seniority will continue to accrue. Once the accrued paid time off runs out, seniority accrual stops, and the employee has 10 weeks remaining of unpaid leave under the FMLA. This ensures that a benefit promised under the CBA, like accruing seniority, isn't withheld from an employee taking leave because it was only promised during paid time. Also, a footnote reminds readers that an employee may get, but is not entitled to, a benefit on his or her own, like seniority, depending on the employer's policy. In this case, because the employer had a written policy that accrual continues only on paid leave, that benefit is protected and applied during paid time off used during FMLA leave.
Our third and final letter deals with a different issue. In this one, published in August of 2019, it discusses whether an employee may take FMLA leave to attend a Committee on Special Education, or CSE, meeting to discuss the individualized education program of that employee's child. This letter looks at the definition of care under FMLA. The FMLA protects leave taken to care for a family member with a serious health condition. In this letter, the employee writes about himself and his wife. They have 2 children, both with serious qualifying health conditions, and his wife has received certification that she will need to take intermittent leave to care for the children. Her employer has approved her FMLA leave to take the children to medical appointments. Now the children are in school, and the school district requires that 4 times a year, a parent attend a CSE meeting to discuss the individualized education program for the children. The meeting is to talk about the needs of the children and to make sure their needs are met under the IEP program or whether changes need to be made. The employer has deemed these meetings outside of FMLA coverage and will not allow the wife to attend the meetings under FMLA intermittent leave. The employer felt that these meetings were not medical and therefore were not considered care under the regulations definition, but the government disagreed. The DOL said it was care. The letter clarifies that care extends to arranging for changes in care, making medical decisions, or finding suitable child care for a child with a disability. In this case, having a parent attend the CSE meeting to review and develop an IEP plan was essential to her ability to provide appropriate care for her children. She's going there to make decisions about her children's medically prescribed speech, physical therapy, and occupational therapy, to discuss her children's well-being, and to ensure the environment is suitable to meet the medical, social, and academic needs of her children. The letter further clarified that the children's doctor need not be present at the meeting in order to qualify for FMLA leave. The letter is a helpful example of how these opinion letters can provide clarity and how to interpret something like make arrangements for changes in care.
Well, I think that covers the 3 DOL opinion letters issued in 2019 on FMLA guidance. We hope you enjoyed this episode of K&L Gates Working Wise podcast series. More episodes in our series can be found at klgateshub.com, and you can learn more about our labor, employment, and workplace safety practice on our main website, klgates.com. Thank you for joining us.
Thanks again for listening to Working Wise. New episodes are available for download through iTunes, Google Play, and other podcast applications. If you have any topics you would like to hear about on the next Working Wise podcast, please send them to workingwise@klgates.com.